Ticket na? Oh.
how do they do reviews and things like that. So this is the publications part. Okay, so next we also have our very own events. Okay, so there are we also have other services, and one of the main and signature services that people know us of is actually IR, Industrial Relations. So going into details, okay, MEF basically, we aim to be the top advocate for private sectors lah, so that we want to safeguard employers' interests and ensure all the business is run legal compliant. Okay, so as a member, okay, I believe, okay, maybe can everyone give me a hands up here? How many of you here are not an MEF member? Can you give me a quick wave so that our admin can have a look? Quite a number. Okay, sure. So this will be a very good chance for you to actually explore our services. Okay, so if by any chance, you all have any questions about the membership, you want to know more about the services, or you think any services that can be in use for your company, please feel free to reach us at membership. I will actually provide the email addresses to reach us directly later on at the end of these slides. Okay, so just cutting things short, members exclusive services including IR. So what IR does for all our members here in MEF is basically we provide guidance, we provide advisory. If you have any questions regarding employee-employer matters, you can come to us. And of course, we actually do court representations as well for our members. Okay, moving on to the big data, as mentioned earlier, besides publication, okay, we also provide insights, to our members, where we run a lot of surveys and polls in relation to the market demands, basically, so that we can actually gather all the information that will be a very important factor, for business decision making, to actually provide that to our members. Okay, after that, we also have our very own IT team. IT team is basically the key person, okay, as we are entering the digitalization era in MEF this year. We actually upgrade our members portal, we actually upgraded our website. We try to fill in as much information as possible into our front end of the website, so that all members or even non-members can more or less get an idea of what MEF does. Okay, and on top of that, of course, these are all the tools that the HR, as a HR, you will need, basically. So you can find our circular, any announcement, how to any updates or any circulars, we call it internally, to be accessed directly from the members portal. So for members here, if any one of you have not logged into the new portal yet, okay, you will actually have to contact membership department as well, so that we can have a quick verification and also guide you how to log in for the first time, because you will need to reset the password first. For non-member, essentially, when you all decided to register, you can just go over to our new website, click on registration, and proceed with the registration. Okay, so next we also have our MEFA, which is MEF Academy. So this is where all the training programs come. They are basically a training provider, and we are HRDC. All our programs are HRDC claimable. So in the event, you actually have any, perhaps training that you would like to provide for your employees, we can even do a tailored session, to go over to your specific venue or your company itself to actually have that topic covered for your employees. Of course, we also have our very own facility here in MEF HQ, is where MEFA is as well. Okay, we also conduct a lot of trainings, which I will be sharing briefly on our website later on what are the upcoming trainings and topics you can expect. So if you are interested, as usual, please feel free to actually drop in your inquiries and registration. We will attend to you shortly. Okay, and lastly, we also have our very own OSH department. We call it Occupational Safety, Health and Environment. So this department is actually a very growing department in MEF, okay, because we don't only provide trainings to about OSH, basically. So we actually have consultants that actually can visit your office, does the safety audits and things like that in line to the government standards, basically. So if you are in need of any of these services as well, this is MEF is where you can reach us lah. Okay, so usually the questions is why MEF, right? So a lot of HR, I believe these are some of the just very common scenarios or challenges that you will encounter one or more. Okay, so if you have any challenges in merging, mergers, acquisitions, and restructuring of an organization, or if you simply are a new entrepreneur startup that you are unfamiliar with any Employment Act or IR regulations, or if you have shortage in industry skilled talents, that's where MEFA come in to provide trainings. Okay, or you just need to stay up to date and need to know exactly how do you actually implement PWP and minimum wage and stuff like that. If you have any challenges on that, we can actually advise you as well, just to name a few. So of course we do collective bargaining agreements and stuff like that, termination and retrenchments, how do you draft the contract, how do you do it properly and correctly, and things like that. So this, just to name a few. Okay, so you need us. So our mission and vision is very simple. Okay, we would like to, we are the primary representative of employers leading in HR development and IR actually to achieve national goals. So our aim here is basically to guide, enhance, and protect all employers, which is our members. Okay, so members benefits include upon joining, okay, you will actually have a monthly meeting which is on a virtual basis. Okay, this meeting is very it's something that a lot of members look forward to, I believe, okay, because it's chaired by our IR consultant, okay, to share the most trendy and I would say relevant topic at that point of time, that as a HR you should know of lah. Okay, so secondly, we also have frequent EDM, we call it electronic direct mailer lah. So this is where you will get any updates, circulars, and maybe any public holidays to observe or not observe and things like that, to actually implement and announce within your company. Okay, so next, advisory and guidance. This one I think is really straightforward as well. If you have any challenges in HR IR matters, okay, you can actually feel free to call in or write in to us, give us a bit of context so that we can actually refer you to the right department to actually to the right consultant, to assist you with the challenges so that we can come up with the solutions for you as well. Okay, so lastly, we also have the members portal as mentioned earlier. Okay, this is a new portal which we are still in the midst of getting all members to log into the portal and access the contents that we provide for members. And lastly, also WhatsApp community by region. Okay, so the difference between the membership perks earlier and exclusive, basically certain services do comes with a charge. Okay, disclaimer over here. Okay, but you can be rest assured that whatever services that MEF is we are providing it at a very, very affordable and reasonable price. So we basically don't charge expensive as a private lawyers lah. So we even go to the extent of doing court representation for our members, consultation, consultancy, and conference seminar, which is all HRDC claimable, as well as publications. We have very, very good and special rates. Same goes to the conference and seminars. We do have special rates for members as well. Okay, so we would like to extend this invitation to actually join us as a member, okay, be part of our growing members. So just a bit of information for everyone here, this has been our members through the years, okay, and of course going through 2025. And at the moment, we actually have 7 branches spread across nationwide, I would say. Okay, so headquarter being the main HQ here. Okay, we take about 70% of we hold about 70% and service about 70% of our members here. Okay, across the states and in Malaysia, we have Penang, Perak, Kuantan, Johor, Sarawak, Sabah, and Malacca is our most recent addition late last year. Okay, so with having all these branches, each and every branch will also be checked by one IR consultant, to service our members. So let's just say in the event you actually have, certain challenges in one of your branches in your offices, across the states, you can always feel free to, reach directly to the branch or give HQ a call so that we can actually assign a consultant to actually assist you with whichever concerns you have. Yeah. So just reading through a bit, this is how membership fee structure in MEF works. Okay, there are 2 different membership category. First is ordinary member. For the first time only, you will need to pay a 500 ringgit entrance fee. Okay, after that is subjected to what is the scale of your company based on number of employees. Okay, so for 20 and below, you just pay 500. So entrance fee 500 plus subscription of 500 for 20 and below, you pay 1,000. That's usually the minimum lah. So if you have more employees, let's just say more than 21 but less than 100,000, so total of 1,500. But in the event you have more than 100 employees, then we will actually stick to this table tier. So for any questions as well, we are more than willing to answer and clarify with you. You can just give us a call or write in an email to us so that we can attend to your inquiries on the fee structure. Okay, so just for everyone's information as well, another category of membership in MEF will be association member. Okay, so these are just some of the categories that we offer lah. Okay, so lastly, I will end my slide over here. If you are ready to join us, please feel free to give us a call, look for membership department, or simply write in an email to us, mef.org.my. Okay, so I won't take up longer of the time. Okay, now I will need to actually get Mr. Nantha to continue his session here. So today he will be talking about how to handle probationary employees. Okay, so welcome Mr. Nantha. Hold on. Okay, give me a second while I share my screen. Okay, Mr. Nantha, welcome.
Okay. Very good morning to everybody, the members of MEF as well as those who are not members of MEF who are attending this session to get to know more about MEF. A very warm welcome to this morning's session. As my colleague Ms. Shen had given an earlier briefing, what MEF is about and what are the services that we provide to our members. And I'm from the Industrial Relations Department, the Assistant General Manager. And IR related services are also one of the key services that is provided by MEF to our members. So as Mission pointed out, this includes advising members on various IR related issues, as well as also representing our member companies in any disputes with their employees that end up in the labor court or the industrial court, right? So one of the areas that can lead to a dispute between the employer and the employee is what this morning's topic is about, that is presented by me, is relating to how do employers manage and handle probationers. Yeah, so this is one area that has also, I've come across many situations where it has led to disputes between employers and employees, and in many times have ended up in the courts. All right. So today's session is all about sharing information and knowledge with our members as well as the non-members on what is the law regarding probationers, what is the employer's rights and obligations of an employer in managing and handling a probationer. So what, from a legal perspective, what is the requirement? All right. Okay, so the starting part of any employment relationship is the contract of service, right? So contract of service means any agreement, whether oral or in writing, whether expressed or implied, where one person agrees to employ another as an employee, and the other agrees to serve his employer and as an employee. So therefore, when a person reports to duty, right, the first thing is they are an employee. This includes a probationer. A probationer is also an employee of the company. And therefore, the employment relationship is governed by the contract of service, the employment letter, the terms and conditions of service between the employer and the employee. So, usually, in most cases, when an employee starts work as a new employee with the employer, there will be a probation period, right? So the terms of this probation period is covered in the probation clause. So what is the meaning of probation? If you look up at the dictionary meaning, the Oxford Dictionary says probation has been explained as the testing of the conduct or character of a person. Second, a probationer is one who is on trial or in a state to give proof of certain qualification for a place or status. So, what this means is a probationer is during the period of probation. It can be anything between 3 to 6 months, depending what is stated in the probationer clause. So the probationer during that period is on what you call this is like on a testing ground, right? Where the probationer has to prove himself or herself to be suitable, to be confirmed in their employment as a permanent employee. So the probationary period is like a testing time frame. Okay, it's a testing. The employer is testing whether the employee is suitable to be given a confirmed status. Okay, so the idea of probation in all service contract is a testing of the character and capabilities of the employee on the employer side, and also a testing of the condition of service on the employee's part. Of course, on the employee's part also, they will be looking to see whether this particular employer is a suitable place, whether the employee is happy to serve with the employer, and that kind of thing. So it kind of also works both ways, right? Okay, now the purpose of the probation period, the very purpose of imposing a probation period is to provide an opportunity for the employer to assess the employee concerned, and ultimately at the end of the probation period to make a decision as to the suitability of the employee for the specified job. So at the end of the probation period, the employer has to make a decision. All right? Now, what is as far as the law is concerned, and when we say law here, we refer to if you are talking of the industrial jurisprudence, then the two main acts that deal with employer-employee relationship are the Employment Act 1955, as well as the Industrial Relations Act 1967. These are the two main acts that deal with the employer-employee relationship in Malaysia. Now, anybody, if you look into this act and you ask this question, What is the status of a probationer as far as the Employment Act is concerned, as far as the Industrial Relations Act is concerned? Now, some of you may be surprised to learn that actually, if you go through the entire Act, Employment Act as well as Industrial Relations Act, it does not mention anything about a probationer employee. These two acts are silent. Right? These two acts are silent. Okay? The Employment Act talks about an employee. It just says employee. It doesn't talk about their status. Similarly, the Industrial Relations Act talks about a workman. The term used is workman. Again, nothing about the status. Whether it's a probationer workman or not, it is silent. So what this means is, as far as the Employment Act and the Industrial Relations Act is concerned, the employment relationship starts on the day one of the employee reporting to work. Okay, when you recruit an employee, a person, from the day they report to work physically, they come and report to work, the employment relationship starts. That means, as far as Employment Act, Industrial Relations, they are now your employee. So then, what about the probationer status? The probationer status is actually conferred on the employee through the, let me just go forward in the slide, through the probationer clause. Okay? The probationary status is conferred on the employee through a probationer clause. So example of a probationer clause, in the contract, it says, you shall undergo a probationary period of 6 months from the date of commencement of employment. Okay? At the end of this period, your performance will be reviewed by the management, who reserve the right to confirm or terminate your employment or extend your probationary period at its discretion. In the event the probation period is extended, at the end of this extension period, your performance will be reviewed by the management, who reserve the right to confirm or not confirm your services. And lastly, you will remain a probationer unless you are confirmed in writing. So the status of the probationer employee is given through the probation clause. Meaning to say, if there is no probation clause in the employment contract, then the moment the employee starts work on the first day, they can be deemed to be a permanent employee because there is no probation clause. Right? So this is something important to take note. Employment Act, Industrial Relations Act is silent on the status of the employee. Probationary status is only effected through the probationary clause. Right? So your probation clause is very important. In the absence of a probation clause, the employee can say, I came to work, I start, there's no probation clause, I am day one a permanent employee. Alright? So this is this one. And the normal time frame for a probationary period, again, the law is silent. You won't find this in the Employment Act or anywhere. It is up to the employer to determine what is the duration of probation. Typically, it is between 3 to 6 months. But again, it depends on individual employers and companies. There have been some situations I've come across where the probation period is 12 months, right? It's up to the employer. So if you have the duration, it must be stated in the probationary clause. Okay, so before we go into the details on how to manage the employees who are on probation, there is a flow chart about how to handle this is an overview. So of course you have the initial probation period. That can be anything 3 to 6 months. This is a typical example. It can be longer. So what are the requirements by the employer during this period? The most important thing is that the employer has a duty to constantly monitor the performance of a probationer. Okay, this is one area where the lack of it and things like that can lead to a dispute later on. So this is one thing. One of the employer's basic duty, most important duty during the probationary period is to constantly monitor the performance of the employee. Right? And in the course of monitoring the employee, if there are any areas of concern about their performance or poor performance and things like that, it is very important to notify or communicate these issues to the employee. This is another very important obligation on the employer's part. Okay, as later on we will see there how the case law deals with this area. It's very important. Not only you must monitor the employee, but any issues of concern about their performance must be communicated to the employee. And when I say communicated, it must be communicated in writing or in some documented manner. This is another very common mistake made by employers where they do not properly communicate issues to the employee during the probation. I've come across numerous situations. Employers tell me, yeah, we had a meeting with the employee and we talked to them and things like that, but it is not documented. Now, that is a big area of concern for employers. So my advice to employers is always keep a record and document whatever issues of concern with the employee during the probation period. And then finally, of course, you will reach the end stage. At the end of the probation period, the employer will have to do a final review or evaluation with the employee. Again, I want to emphasize here, it is not a unilateral meeting, the final review. It is done with the employees present. Frequently, I've come across cases where the employee does the final review in the absence of the employee. No, that is not the correct way. The final review evaluation meeting must be done together with the employee present. Of course, based on that final review, the employer then will make a decision, either confirm or not confirm the employee, or in some situations, the employer may decide to extend the probationary period of the employee. Of course, when you extend also, you must be guided by the terms of the probationary clause. So in the probationary clause, there should be a clause allowing the employer to extend the probation. Otherwise, if there's no extension clause, this also can lead to a dispute. And if the probation is extended, then during the extension period itself, the employer has to make sure they do what they are required. Monitor the employee consistently during the extension period, and then make a final decision at the end of the extension period. Okay, so this is a basic overview on how to handle an employee during the procedures when dealing with the probation employee during the probation period. Okay, so you have the probation clause. So you must have the extension period also mentioned in the probation clause. All right, and okay. Now, during the probation period, can employment terms and conditions be different from probationers compared to a permanent employee, confirmed employee? That is not an issue. It has been a norm for the employee on probation to be subject to different terms and conditions as compared with the confirmed employees. So probationers, yes, of course, the employers can put them on different terms during the probation period. Okay, probationers need not be afforded the same benefits and perks as permanent employees. Of course, after they are confirmed, then their status is similar to a permanent employee. Then the same terms as permanent employees can be extended to the probationer. So, but of course, it depends on individual employers. What are the terms and conditions that you want to impose on a probationer? So let's look at as we go along in this presentation. I will just share with you some examples of cases, actual cases that have been gone through the industrial court, and what is the court's finding or evaluation when it comes to dealing with a probationer. So on the rights and obligations of a probationer, we have this case. Some of the cases may be a bit older, but the principle is still applicable until today, right? So here we have a famous case. They're dealing with probationers. So here the court held that being a probationer, the employee had no substantive right to the post. So on probation, you're on trial, right? The court says he holds no lien on the post. That means a probationer is not a permanent employee. He's on trial to prove his fitness for the post which he offers his service. So during the probation, his character, suitability, capacity as an employee is to be tested during the probationary period. And this is important. One of the things that I always advise employees, during the probation, the employee is being tested not just purely on the work performance. Okay, a probationer, it can be assessed all round, meaning to say their character, their what they call this disciplinary record, attendance record, tardiness, everything, not just specific. An employee can be a good work performer, but if he keeps coming to work late constantly during the probation, then the employer can use that as a grounds to say, hey, you are not a suitable person to be confirmed because of your persistent late coming. So it's not just work performance that you are being assessed. It's all round. Okay, right. So as the Equatorial Timber case highlighted, there are many cases, many abundant authorities to support the view that the employer has a contractual right to terminate the services of a probationer without notice and without assigning any reasons, and no inquiry need to held for such purpose. For termination of the probationer during the probation period, it is not a punishment or dismissal, but simply that of termination. However, when the validity of the termination is challenged, because you see at the end of the probation period, if an employer makes a decision, okay, now upon expiry of your probation period, you are no longer an employee of the company because the company never confirmed you. The non-confirmation is similar to a termination, right? Because 6 months you were employed as a probationer, and then the company decided, sorry, I cannot confirm you, so after your end of probation, you are no longer my employee. So it is a form of termination. So when the validity of the termination is challenged, let's say the employee is not satisfied, that's where they will bring this matter to the court, and they will file a case, right? So if the validity of the termination is challenged, the court must be satisfied that such termination was bona fide. Bona fide means genuine exercise of the power conferred by the contract. And where there is suspicion of unfair labor practice, then the court will not hesitate to interfere with the termination, and the employee should be given proper relief. So this is the key thing, right? If the non-confirmation is challenged, then the court will look into the conduct of the employer in making the decision to not confirm the employee. Okay, so this is where your obligations as an employer must be properly done. Okay, so here we have a Court of Appeal case, Kalia Abbas versus Pesaka. This is also another landmark case in the probationers. Here, the court ruled that when it comes to the termination or non-confirmation of a probationer, the probationer has the same rights as far as the termination rights as any other employee, as a permanent employee. So what this means is many employers, they make the common mistake or assumption, oh, this employee is a probationer. So therefore, when I make the decision to not confirm or terminate the probationer services, I don't need to follow the same requirements that I need to do when I want to terminate the services of a permanent employee. So the employee assumes, oh, probationer, I can treat them differently. You know, I don't need to do so much of, kind of like a due process and things like that. At the end of the probation, I just say, sorry, I don't need your service. Thank you very much. Many employers make this mistaken assumption. So the Court of Appeal has confirmed no such thing. As far as the law is concerned, the case law, probationers have the same rights as a permanent employee when it comes to the issue of termination or non-confirmation of employment. Okay, so here the employee joined the company as an admin assistant and was placed on probation. At the end of the probation, her service was terminated on the ground that she had not met the standard requirements for confirmation. Okay, that's all the employee said. So the matter went to the court, and then the Court of Appeal held that it is our view that an employee on probation enjoys the same rights as a permanent or confirmed employee, and his or her services cannot be terminated without just cause or excuse. The requirement of a bona fide, genuine, is essential in the dismissal of an employee on the probation. And if the dismissal is found to be culpable exercise of some of power to dismiss or result of discrimination or unfair labor practice, then the industrial court will interfere to set aside such dismissal. Okay, so it is now you should be very clear when it comes to non-confirmation or termination, the probationer have the same rights as any other employee. I think this is very important for employers to be aware and take note. Okay, you cannot treat the probationers differently when it comes to termination employment compared to a permanent employee. So the absolute right of the employer under common law to hire and fire is no longer available to him lah. So you please don't make the mistaken belief, oh, you are a probationer, as I'm the employer, I can just make the decision, I don't want you at the end of the probation, thank you very much. No more, no such thing. Okay. Hence, employers in terminating employee services cannot use the excuse that he was on probation and therefore the employer have a right to terminate his services summarily. Summarily means without going through the due process. Summarily means I just terminate you based on the contract, notice period, and off you go. So no, that kind of termination is invalid, unlawful. Okay, they have the same rights and due process available to a probationer. Okay, so the law and guide, now we go into a bit more detail on how you actually manage those employees who are on probation. So, taking the findings from the court in all those cases that end up in dispute. So, in this particular case, the court had summed up quite clearly on how an employer is supposed to deal with the employee on probation. So the court here stated, an employer should be very slow in dismissing on the ground that the employee is found to be unsatisfactory in his performance or incapable of performing the work in which he or she is employed to do, without first, so there are three conditions lah. So the first one is without first telling the employee of the respect in which he's failing. So this is what I stated earlier. Employer must communicate to the employee what are the employee shortcomings. And when I say communicate, please put it in documented or written form. And then number two, warning him of the possibility or likelihood of dismissal with non-confirmation on this ground. Okay? Where necessary, the employer has to give warnings. This will support the employer's case if the matter ends up in the dispute. So warning is important where necessary. If the employee is not improving after being informed of his shortcoming, then the next step will be you have to issue warning letter. And of course, the other thing is when the employer have communicated to the employee of the shortcomings, you must give the employee reasonable opportunity to improve the performance. Another common mistake employers make is that they only raise up all these issues at the very end of the probation period. Let's say the probation period is 6 months. The employer only brings up all these shortcomings, issues and all that in the 5th month. Now, if the employer were to do that, then the issue is, was the employee given reasonable time to improve? Unlikely. You tell the employee on the 5th month that you have all these problems and his confirmation is due in the 6th month. Is it fair to the employee? Is the employee given reasonable time to improve? Unlikely. So this again can be a problem. So that's why any issues should be brought up consistently and at the earliest possible opportunity. Okay, and of course, warnings there. You need to warn the employee, and warning is important because it warns the employee that if you don't improve, it may result in your non-confirmation. Then it's up to the employee to respond. So this again, this another case summarizes the same thing, the same principle. All right. So in this case, the court said the workman must be warned about the performance. The workman must be accorded sufficient opportunity to improve, and notwithstanding the above, the workman failed to improve the performance. Right. So 1, 2, 3. You must communicate to the employee what's the problem, give the employee the opportunity to improve, and where necessary, you must give the warning letters to the employee on the consequences of non-improvement. Okay? Right. A further point to note is the employer must allow the employee to complete his probationary period before he is dismissed from service or not confirmed on the grounds of poor performance. Yeah, this is another point. Frequently, employers ask, the employee's probation period is 6 months. So the employer will come across situation, the employer asks, is now probation is 3 months or 4 months. This employee is, no good. Can we terminate for poor performance halfway during the probationary period? The answer is no, right? If you are going to make a decision on the employee based on the performance, employer must give them the full opportunity of the probation period to prove themselves. Otherwise, the employee can turn around and if you terminate halfway, say, there's a balance 3 months in my probation period. You did not give me the opportunity to prove myself, right? So, poor performance, generally speaking, the decision is made at the end of the probation period. Not beginning, not halfway, at the end. If an employee commits a misconduct, a serious misconduct, that is a different issue. That one, action can be taken anytime. Let's say after 1 or 2 months, the employee committed some serious misconduct, like say for example, fraud or cheating or whatever, then you can take action immediately. You don't have to wait until the end of the probation. But if you're talking of performance assessment, the decision is at the end of the probation period. So this case confirms that. In this case, Suliana Muhammad Isa selaku kanak-kanak kat Selangor, the High Court held, in my view, is unfair, improper for the respondent, the company, to prejudge the performance of the applicant before the expiry of her probationary period. The applicant should be given the opportunity to complete her probationary period. She had been denied this opportunity, therefore the respondent, the company, had breached what it agreed to do. So you have a probation period, performance, you judge at the end, not halfway. Okay? Yeah, so in dealing with the dismissal of a confirmed employee or permanent employee, the court has held generally it's appropriate employer ought to warn lah. So warning is important. And I always tell the employers, please document your warnings. So I have many situations, employers come to me and ask for advice. You talk to them, the employer will say, yeah, I had meeting with the employee, I did this, I did that, everything, but unfortunately, it is not documented. Now, ladies and gentlemen, one reminder to all of you all, if the dispute goes to the court, the burden of proof to justify the decision of non-confirmation of termination is on the employer. Employer have to prove and justify the reason you made for the non-confirmation. So how do you do that? By way of evidence. And if you do not have the documented evidence, then it makes the employer's life very difficult in a court case. So this is another very important point I wish to share with the employers, the importance of keeping a proper documented record of whatever steps that you have taken in dealing with a probationer employee, including warnings. And when we say documentation, nowadays, you have all this technology, emails, WhatsApp also can be messages also can be accepted as evidence in the court. Any form of documented communication that can be verified is acceptable. Need not necessarily be in a formal letter, right? Any way you can document and verify it, it can be accepted as evidence. Okay. Okay, so we have many cases there. So if you are talking about an employee who is inefficient in their work performance, then what do? First thing is you highlight to the employee what's the problem, what's the issue, right? Then you must give the employee reasonable time to improve, and only then, if there's no improvement, can you possibly say action to the extent of non-confirmation. Okay. Now, when it comes to the issue of warning, one of the questions that comes up is warning necessary for every situation and every level of the employees? Well, there have been some case laws to say that the more higher up you are in the hierarchy of the company, especially those holding senior positions, there is less the requirement that the company must issue written or formal warnings. So this was one such case. In those older case, the principle is the same. So the court said those employed in senior management may by the nature be fully aware what is required of them and fully capable of judging for themselves whether they are achieving that requirement. In such circumstances, the need for warning and opportunity for improvement is much less apparent. So obviously, if you employ somebody as the CEO or the head of a division or the very senior, they are expected to be able to perform their job functions with minimal guidance, minimal coaching, right? Compared to a lower level employee. Okay, but my advice to employers is no matter how high up the employee is, it is always safer and better practice for employers to where there are issues, any problems, it is always better for the employees to put on record. Even you may not issue a formal warning letter or things like that, but at least put on record that these things happen, we had this meeting and you need to communicate this to the employee. Okay. So this is another example of a case where the employee, senior employee, he had a long experience in this area of employment. Expertise. He had been working for 27 years prior to joining the company, and he was holding the post of production manager. So the court held that claimant employee cannot expect the company to issue warning letter to him. He must be fully aware of what is required by the company, and he must be able to judging himself whether he was achieving the requirements. So it cannot be that he said, "Oh, you didn't give me warning letter, therefore I don't know, I was not performing well." Well, you are a production manager. If the production is not going to plan, you should already be aware you are not performing your job position requirement, right? Okay, making a decision whether to confirm the employee or not confirm or extend. So at the end of the probation period, the superior has to conduct a final review of the probation's performance during the probation period, and this has to be done, as I said earlier, face to face. And of course, ideally, the both parties will sign off on the evaluation documentation, right? So the employer then will have to make a decision lah based on that outcome. Of course, if everything is good, goes well, then the employer will confirm the employee. Or things not so good, then employers may have to make a decision, either confirm or not confirm or extend. Now, talking about extension, can the probation period be extended? Again, if you go and look at the Employment Act or anywhere, you won't find the answer. You have to come back to the probation clause in the contract. What does the probation clause say? Ideally, the probation clause should say, yes, company may extend the probation for a certain period if the performance is not satisfactory. Now, what happens if the probation period clause is silent on this? Then you have a headache. The employee can turn around and say, what is your grounds to extend? The probation clause does not give any extension. You won't find this in the Employment Act or Industrial Relations Act. So you have a headache, right? It may become a dispute. So be very careful of the probational clause. The probational clause must stipulate there is a possibility for the probation to be extended. Okay, so this is another important factor. Can be extended, but again, this is another issue. An employer simply cannot extend the probation for the sake of extending. No. When the employer makes a decision to extend the probation period, you must make sure you are able to justify why the employee's probation is being extended. Just like you make a decision to not confirm, you must justify. Similarly, to extend the probation period also, you must be able to justify to the employee what is the grounds that the probation is being extended. This is very important. Doesn't mean there's an extension clause, you can automatically extend without any justification. Again, you do that, it can lead to a dispute. Yeah, so you have to be careful on that. The decision of the company has to be communicated to the employee in writing. That's why if you recall, at the very beginning, the probational clause, there is a sentence there that says, you will be informed of any confirmation in writing. That means, until the employer issues you a written letter of confirmation, you will remain a probationer. Right? So whatever decision the company has made has to be communicated to the employee in writing. If the company decides to extend the probation period, they will need to conduct the final review at the end of probation and make the decision. Company must have evidence to justify the extension. Okay. All right. Now, what happens in the worst case scenario? Termination, non-confirmation. So how do you go about it? Again, there's plenty of cases in the industrial court, as we just saw just now. The importance of the employer to be able to justify their decision, just cause an excuse. Just like a permanent employee, you want to terminate for whatever reason, you must provide a justified reason with sufficient evidence. The same rules apply to a probationer. Okay, there's no doubt about that. Okay, you simply cannot make an arbitrary decision. End of probation. Okay, thank you very much. We find you not suitable. No, I've come across so many cases like that. How we want to justify is a problem. Right. So there's the there's the High Court decisions on this case, similar kind of issue at the end of the probation period. The High Court said it was open to the company to either continue or discontinue the services of the probationer. Right. The probationer, the applicant, by the way of being a probationer, had no say in the matter, and as the employer was fully entitled to terminate the services upon their evaluation. So the evaluation criteria is very important. That's why I say at the end of the probation, a proper evaluation session must be done, must be documented, because that will be the basis upon which the employer will make the decision. Later, if any dispute goes to court, the court will want to see. The court will want to see, hey, where is your evaluation of the probationer, the documentation at the end of the probation period? What is the basis? Okay, I've come across cases where the employer put in the letter of non-confirmation due to poor performance after being evaluated during your performance review. But then when I asked the employer, where is the performance review document? They cannot produce. They say we had a meeting with the employee, it's communicated. No, that is not a performance review documentation, right? It must be in black and white. Okay, so this is another very important point to highlight to employers. Okay, so what is the status of a probationer at the end of the probation period or after the probation period? Okay, sometimes we do have situations where the employee, for whatever reasons, they work past the probation period. So you have a probation period for 6 months, suddenly you find after 7 months, 8 months, the employee is still working, and the employer has not informed them of what is their status, whether they are confirmed, whether they're going to be extended, or whether they are not confirmed. So in those kind of situations, what is the status of the employee? Can the employee assume, oh, I've worked past the probation period, so now is 7 months, 8 months, I am automatically confirmed? Well, luckily for employers, that's not the case lah. There's no assumption of automatic confirmation. Generally, the law requires there must be a written confirmation by the employer. That's why I mentioned in the earlier clause, you should put a clause in the probation clause. You will be informed of your confirmation in writing. Until then, you remain a probationer. Generally, that is the rule. However, we have so the general rule is no action is taken by the employer by either by way of confirmation or termination. When the employee works past the probation period, generally speaking, the employee continues to be in service as a probationary employee. However, there are some circumstances where even though no letter of confirmation is issued, the probationer may be regarded as a confirmed employee if the employer, by their own conduct, have implied or done something to give the impression to the employee they are confirmed. Typically, what happens is sometimes employer, they allow the employee to work past probation period, then they treat them similar to permanent employees. One of the common things, they allow them to use annual leave. They even give them increment. They even give them a bonus at the end of the year, that kind of thing. So this kind of action by the employer is you are treating the employee similar to a confirmed employee, even though you have not issued a, what do you call this, confirmation letter. So this is mean by conduct, you have treated the employee similar to a confirmed employee. So please avoid that kind of situation. Okay. Now, the liability to the employer, if the case goes to the court, well, the good news for the employer is that the maximum a probationer can be awarded in terms of back wages in the industrial court is 12 months back wages. It is lesser than a permanent employee. But having said that, of course, even 12 months back wages it can be a substantial amount to the employer. So you have to be very careful on this kind of situation. Okay, so we can wrap up by just giving a quick run-through checklist for employers. What is your duty regarding to the probationers? Okay, first, of course, you have to check whether the employee's temperament is the right person for the job. For example, if you employ a crane operator, you must make sure that before you employ them, you don't employ somebody who's fear of heights, that kind of thing. Then it doesn't make sense, right? So employers, you must know the employee you are bringing in, number one. Then, of course, if there are issues during the duration of the probation, please inform the employee of the weakness in writing. Provide opportunity for the employee to improve, and if necessary, especially the lower level employees, you may want to provide them some training or coaching or what to improve on their job performance. Warn the employee of the consequences if he may not be confirmed, if he does not improve, right? So counseling and coaching is, if it's possible, you can do it, especially the lower rank employees. And then at the end of the probation, if necessary, you can extend in writing. And of course, the last one is non-confirmation. Non-confirmation is a form of termination. So what are the pitfalls? What are the common mistakes employers make in handling a probationer? The most common one is lack of warnings issued to the employee on the performance. The employer says you're a poor performer, but during the entire 6 months, there's no warnings given. So that kind of is a bit contradictory, right? If the employee is not performing and you have given him coaching and guidance and all that, then you must warn the employee in writing. Okay? Sometimes employers, they do things that is contradictory in terms of you giving the employee good evaluation marks, you give the employee increment, and then after that you decide, oh sorry, now you're not suitable to be confirmed. So please don't do anything that is contradictory. Okay? I've come across cases where during the probation, the appraisal given by the superior is good. But yet come at the end of the probation, the employer says, I don't want to confirm you. So it's contradictory. So the employer's action must be consistent. No appraisal done at the end of the probation period. Again, this is a big issue. You must do a proper evaluation of the probationer employee at the end of the probation. Okay, employee on medical leave during probation or it comes to end, please don't issue non-confirmation letter. The correct thing to do will be to extend the probation to make up for the lost time during the medical leave. That will be the correct way. Don't issue non-confirmation letter to an employee who's on medical leave. That will also lead to a dispute. Okay? Termination simpliciter is what I mentioned just now. At the end of the probation, without any justification, without any evidence, the employer just says, okay, your probation period has ended. Thank you very much. Goodbye. No such thing. Probationers have the same rights as permanent employees of due process when it comes to non-confirmation. Of course, promoting an employee during probation, again lah. I come across, people might find this a bit odd. Why would you promote a probationer and then you say I don't want to confirm, right? But it happen, all right? Other things is allowing probationer to take annual leave when no provision annual leave until confirmation. So the common practice is you allow the probationer to accumulate their annual leave, but they only able to use it after they are confirmed, right? And recruiting, interviewing another person for the same position while the employee is on probation and subsequently not confirmed. Yeah, I mean, if this employee is not working out, you please look for a replacement after they are not confirmed, not when they are still occupying the position. And then you place an advertisement in the media, and then that person says, hey, I'm sitting working here and the employer is placing a vacancy for the same position. This will show that the employer is not acting in good faith. All right. Documentation important. Job description stating the list of what the employee must do is important. Frequently, when there's no job description given to the employee, then there's a dispute again. What are they supposed to do? The employee says, I don't know what I'm required to do. Employer will say, no, you're supposed to be an unnecessary dispute. So please have a proper JD given. Okay, I think that comes to the end of the my session. Okay, so I'm happy to have a Q&A if time permitting.
Okay, hi everyone. Mr. Nantha will be going into the Q&A session later on, but here before we end, he will also be sharing a bit of preview and teaser about our next national conference.
Yes, thank you, Michelle. Okay, just to share with the members as well as the non-members who are present today, we MEF will be having our national conference on the topic of workforce upskilling, well-being, and safety. We have already been promoting this conference, and we have quite a numbers who have signed up. It is in May 7th and 8th. I think those who are interested to attend this conference, a lot of prominent and speakers and experts in this area, various areas and topics, they will be at the conference. Those who are still interested, I think you can still make the early bird kind of registration and get some perks. Okay, and the email for the contact persons are there. You can email conferences@mef.org.my, or you can just call our Secretariat Office 74987200 to inquire more about this national conference. So we look forward to your attending and supporting MEF, and also upskilling and getting the information from participating in the conference. So thank you for that.
Okay, thank you, Mr. Nantha. I believe everyone here have a very great insights today about the topic of probation employees. So as mentioned, as our national conference right now, we are actively taking in RSVPs. So feel free to email or call into our sales team, Puan Musfira or Cik Wani. They will be actually handling about the national conference. So you can scan over here if you want to get the full info on the brochure. And of course, if you are ready to register as well, this is the link. These two information is all completed up in MEF website as well. Just go over to mef.org.my, go over to conference upcoming events, and you will actually find it there as well. Okay, so I will be stop sharing my screen a while we will be also coming up with the questions to answer. So Mr. Nantha, this is the questions that we have received. Okay. We have a total 16 in total.
Okay.
So I will be doing it together. We won't be sharing any screens here, by the way.
Okay.
So Mr. Nantha will read out the questions,
right,
and then you can just answer like this.
Okay. Okay,
first
try
one.
to answer as many as possible during the time allocated. How many months can extend a probationer? Again, like I mentioned during my presentation, when it comes to time frame, the law is silent. But generally, we do not recommend to extend a probationer indefinitely. Normally, you extend one time or the maximum two times, then the employer should be able to make a decision. You do not need to extend 3, 4, 5 times before you make it. Doesn't make sense, and it definitely can lead to a dispute. So you extend once or twice based on the probation clause, and then please make your decision. Okay. Contractual employee, is probation required? Again, it's up to the employer. It's up to the employer. Say you have a fixed term contract for 1 year, you want to put in a probation clause, it's up to the employer. You can, if you want, or if you don't want, it's fine. Okay. So it's up to the employer. Can I ask if there is a clause for time frame we need to confirm employment? Can we send a confirmation? Well, ideally, you make the decision at the end of the probation period. But sometimes, if there is a lapse over into the 6-month probation, you haven't made a decision, it's in the 7th month or what, it's okay. It's okay. You can still make a decision in that time. Like I said, doesn't mean they work past the 6-month period, they are confirmed. No such thing, right? So if there is a slight delay in the decision-making process, it's not a problem. Okay. So how do we move on?
Okay, history is done, right?
Yeah.
Okay, moving on to here.
Okay. Will there be a consequence of complying later than the C period? So no, if it's a reasonable time after that, it's not a problem. If the probation is ending 17 April 2025, when's the right time? So the right time will be probably in the last week of the probation. Okay, if you ask me when is the right time to do the final evaluation, it will be towards the end of the probation, usually in the last week or something like that. All right, not too early. Not too early. Don't do 1 month before the end of the probation period, because there's still 1 month to go, right? So you do in the last week also, it should be a problem. Why do some companies don't allow leave for probationer? Well, annual leave usually something, if you look under the Employment Act, it says you have to work minimum 12 months before you can utilize your earned leave. So usually annual leave is something that is given to permanent employees. That's why many companies say during probation, you're not entitled for paid annual leave. Okay, fine. Generally, what is the maximum number extension of probation or should the employer do? Again, like I mentioned just now, the law is silent. It never tells you can extend once or twice or twice. But based on experience, okay, dealing, if you extend an employee too many times, then it will definitely lead to a dispute. Say you extend 2, 3 times, 4 times, then you make decision, I don't want to confirm. The employee will not accept it just like that. It's sure it will lead to a dispute. So my advice is, please don't extend too many times. You extend once, you extend twice, you should be able to make a decision already. Okay? Can terminate employee once extension done? Do we need to pay compensation? No need to pay compensation. And as long as the probation clause states that at the end of the probation, you may not be confirmed without any further notice, then no problem. So at the end of the probation, you make a decision and it takes effect immediately, right? There's no need to pay any compensation to the employee. Recruiting, interviewing another person for same position, if current employee resign due to pressure, I mean, if an employee resign, of course you can look for a replacement, right? No problem. When should we inform the employee his confirmation or termination? Well, after you made the final evaluation meeting, you come up with a decision, you can inform the employee. Okay. What to do if probation frequently medical leave during? Well, put this on record. Put this on record. And of course, like I mentioned to you just now, probationer not just evaluated on performance, all their other records. So if an employee is frequently on medical leave during the probation period, the employer should put on record, and at the end of the probation, that can be one of the factors the employer taking into account when you make your decision. Okay? But please put it on record. Don't keep quiet. You keep quiet means you are accepting it. Okay? You are not happy with the employee taking a lot of MC, bring it up to them, highlight the concern. It's up to the employee then to improve their attendance. Okay? If employee offer contract for 2 years, do we need a probation clause? Yes, you can put a probation clause. Okay, it's up to you all for a fixed term contract. May I know if we need to serve notice for probation staff or non-conforming? The issue of serving notice or not, I know some employers, they want to play safe. So what they do is when they decide not to confirm the employer, if he says the notice is 1 month, they pay in lieu. They say, I don't want any headache problem. Okay, I don't confirm you at the end of the probation, my decision, but the notice I pay in lieu. It's up to the employer lah, right? Or the contract says very clear, probation clause is very clear. End of probation, there will not be any further notice if you are not confirmed. So, you follow the probation clause. The probation clause is clear, no further notice, then you do not have to provide any further notice. If employee is found unsuitable in 2 or 3 month probation, is 1 month notice required. If you dismiss an employee for misconduct, disciplinary misconduct, if they are found guilty, they can be terminated after due process with immediate effect. Okay? But like I said earlier, if the grounds for the non-confirmation is poor performance, then it should be done at the end of the probationary period. I think that one answers the next question as well. If somebody is stealing money during probation, okay. How can we terminate contractual employee before end of contract? Well, if you terminate before end of contract, you must have a justifiable reason. Right? Staff and habitual late coming during probation, is better to terminate some misconduct. I think this one, if habitual late coming after warning letters, you can go for non-confirmation. But warning letters are very important. Can we terminate a staff under probation, even extend probation? We feel, of course, you have set justified grounds for the poor performance. You can, of course, go for non-confirmation. Okay. Are we done? I think.
Okay, there are a bit more new questions that came in.
Maybe we'll just
So,
do.
let's just say we do the last 4
Okay.
until here to here.
Okay. Here?
Start from
Okay.
here. All the way up.
When should we inform the employee of his confirmation? I think I answered this earlier.
Sorry.
A minute ago, okay? I think I answered this already.
Let's start here. The last 4 questions.
What is the maximum number of months extension can employee do? 6 months. This one, you follow your probationer clause. Yeah? On the maximum number of months they can be extended. Okay? I think this answered already. Yeah. Answered already.
Okay. If that's the case, that will be all from Mr. Nantha today. Okay, and before we end this official session, okay, if I can get everyone to open up your camera, just to have a quick screenshot, if everyone here don't mind, okay, just to mark our official ending for today's session, that would be great. So can I get everyone's help to actually open up your camera just for a while? And let's do a quick screenshot. Screenshot. Thank you, everyone. Wait for a while more while we hope to see a bit more faces. Nice, everyone, beautiful face. Okay, so I hope today's session, if you guys have any questions, regardless whether you have questions about the conferences or membership, or even Mr. Nantha's topics and whatnot, feel free to write into us. Write into membership. Upon review and everything, we will be able to refer and guide you accordingly.
So for the members present, thank you for your continued support with MEF, and for the non-members, please make contact with MEF to enjoy all our services and benefits.
Okay. So, ready? Let's do a quick screenshot.
You ready, everyone?
Yes, ready.
Smile.
One,
Satu,
two,
dua,
three.
tiga. Okay. Hold on now, one more time. Sekejap.
More.
Okay.
One, two.
Three. Okay, nice.
Okay, thank you so
Okay.
much, everyone. We will officially end this session today. Thank you.
Thank you. Okay. Bye-bye.
Okay. Okay, thank you. The questions repetitive. I thought yang baru tu is baru. Tak, maksudnya dia